Hi, everybody, and welcome to episode 12 of Reappropriate the podcast. I know that I promised in the last episode that we weren't going to have any more until the new year, but then some stuff happened. Lots of stuff happened, actually, since the last time we recorded, and I really couldn't help myself. I felt like we absolutely had to have another podcast episode. So I'm really excited tonight to have a conversation about, we've had a lot of conversations about digital activism and how we can use Twitter and social media for social change. But one thing we haven't really talked about is sort of the downside or the dark side of the internet as a new tool for social change. And that's the issue of online harassment. And I think this came to the forefront in the last couple of weeks with regard to a Supreme Court case that was heard, I want to say late last month or a couple of weeks ago, and it was the Alonis v. United States case. And I really wanted to have an episode to talk about it, especially because it seemed like coverage on this case wasn't too great. And so tonight I have, because I am not a law person and I don't know anything about this, I decided to bring on the expert. Tonight I have with us a special guest, Professor Nancy Leong, Nancy Leong, who tweets at Nancy Leong and who blogs at nancyleong.com as well as at feministlawprofessors.com, I believe it is. And Nancy, do you want to introduce yourself and tell us a little bit more about yourself?
Sure. Yeah. First of all, thank you so much for having me and for inviting me to talk about this great topic. I think it's really timely, both because of the Alonis case, obviously, but also because, I think in some ways the year 2014 has kind of been the year of people looking at this dark side of the internet, as you called it, and looking at harassment and looking at threats. And we can talk about Gamergate, and we can talk about the stolen celebrity nude photos. We can talk about all of that, but I think it's a really timely topic, and so I'm really glad that you're, devoting a podcast to it. So just a little bit about me. I'm a professor at the University of Denver Sturm College of Law, which obviously is in Denver. Denver is also my hometown, so I'm very happy to be back here. I kind of lived all over the place. I went to college in Chicago and law school in the Bay Area, and then clerked in Portland, Maine, of all places. I was in law practice in Washington, D.C. For a few years, and eventually found my way to academia. I'm leaving out a lot of sort of steps along the way. But so in terms of what I do, the classes that I teach are all civil rights classes. I teach constitutional law. I teach criminal procedure, which sounds boring, but it's actually one of the most exciting classes there is. It's the Fourth and Fifth Amendments. So what can the police do to you? What privacy protections do you have? So that's a different topic, but a very timely one as well. And then I also teach a class on constitutional litigation, right? So if somebody violates your constitutional rights, how does all of that get litigated? So I do that. My research relates to the same kinds of topics, civil rights and civil liberties topics. I also write a lot, as you know, about race discrimination, gender discrimination, discrimination on the basis of sexual orientation and identity more generally. And within the past couple of years, I've begun writing more for the popular media. I've published in The Atlantic, on Salon, Huffington Post, and I think you mentioned my blog, but I'll say it again. I blog at nancyleong.com, and if you just go to my Twitter bio, you can click through from there.
Awesome. And so this is why everybody who's watching right now, I invited Nancy on, because as you can see from her CV, she is basically the perfect person to be talking about the intersection between, I think, online writing and free speech concerns. And so that's the conversation we're going to try and tackle in the next 45 minutes or so, and really just try to parse what the law has to say about online harassment relative to whether or not it can be considered illegal, and what the ramifications are for those of us who spend so much of our time writing online. So for those of you who are streaming us right now, there are a couple of different ways that you can engage in the conversation, and we actually invite you to engage in the conversation with us. Even though it's me and Nancy talking, we really want this to be a kind of conversation that everyone can get involved in. So if you are streaming right now, you can interact two ways. First of all, you can tweet me at @Reappropriate, and I have my iPod next to me, and it will bing, and I will try to read your tweets on air as they come to me. So you're going to tweet at @Reappropriate, which is on the screen right below. The other way you can interact with us is if you are streaming through Google Hangouts, you'll see on the right-hand side a question and answer app where you can type in questions. When you do that, we can actually see those questions, and we will attempt to answer them on air. So you have your choice of how you can interact with us, and we really invite you to do that. So as I mentioned, I am not a person who is particularly well versed in all of the literature that is American law, or most of the things that they teach you in law school, which is why they have a whole school about it. So on my Facebook feed a couple of weeks ago, I read about the Alanis case, and I was wondering what it was and why we aren't talking about it. So the first thing is, what is it? Nancy, do you want to give us like a quick elevator speech on what this case is really about?
Yeah, so let me start with the facts, because I think that's really important to understanding the law. So Anthony Alanis is this guy, and he was married with 2 kids. He worked at a nearby amusement park, and then in 2010, his wife left him. She took their 2 kids with him, and I think that it's fair to say that he did not handle the breakup very well. He, so first of all, he got fired from his job, and this was in part because he posted some disturbing messages on Facebook about his coworkers, including a picture of one woman who had previously filed a sexual harassment complaint against him, a doctored picture of him holding a knife to her throat. So he got fired, perhaps not unsurprisingly. And then he continued his Facebook posting activities with I think what most people would agree is a pretty disturbing series of messages about his wife. And let me actually read some of these. I don't want to take all the time, but I think that, I think it'll really help the conversation to have a sense of what he actually said. So,
absolutely. And I didn't even know he posted a picture of his wife with the knife thing. I think that actually
so that was actually a coworker who
okay.
Sexual harassment. Yeah, I mean, this guy has a lot of problems with a lot of people. It's quite a complicated factual record, and I actually think it's relevant that he has problems with a lot of different people in terms of some of the legal standards that we're going to talk about later, right? Because one of the questions is whether his wife was reasonably in fear of him. But so here's some of the things he said about his wife. So he said, "I'm not going to rest until your body is a mess, soaked in blood and dying from all the little cuts." Later, he said, "If only I knew then what I know now, I would have smothered your ass with a pillow, dumped your body in the back seat, dropped you off in Toad Creek, and make it look like a rape and murder." Another said, "So hurry up and die, bitch, so I can forgive you." Another said, "Revenge is a dish that is best served cold with the delicious side of psychological torture." And so there were more messages than this, but I think that gives you kind of the idea of the things that he said. And so on the basis of this, his wife, Tara, took out a restraining order against him. And my understanding is that he honored the restraining order in terms of the physical specifications, but he continued to post on Facebook about her. So he, it's kind of the same thing, and it's pretty repetitive. And so in addition to this former coworker and his wife, he also posted statements about committing kind of violent acts against people in his community. So, for example, he said at one point, "I've got enough explosives to take care of the state police and the sheriff's department, and then enough elementary schools in a 10-mile radius to initiate the most heinous school shooting ever imagined. The only question is, which one?" And so perhaps not surprisingly, these statements attracted the attention of the FBI. And so a pair of FBI agents came to his doorstep, and he talked to them. And then he just can't stop. So after that happened, he posted online, let me find the quote. So
before you find the quote, can I ask,
yeah.
Were they all in the format of like rap lyrics? Because I know that's part of the case. Is he argues that they were all in the form of rap lyrics.
Right. So yeah. So let's talk about that now. So these were all to different degrees in the form of either in the form of rap lyrics or related to this rap persona that he claimed to be adopting. And what he said about these postings and these things that he was writing was that they were therapy. essentially. Like they were a way for him to vent his emotions, and they were a way for him to communicate these ideas without actually harming anyone physically. No, so I think when you cut out, we were talking about sort of the rap medium and how sort of after his wife had left him, he decided that he was an aspiring rapper. And so his Facebook page, these things to greater and lesser degrees were framed as rap lyrics. And he had a bunch of disclaimers saying things like, this isn't meant to be taken seriously, this is art, this is rap. These are some lyrics that I'm working on, right? But it's not meant to be taken seriously. It's just therapy for me. And so I was just going to mention one other thing that he said when the FBI showed up on his doorstep. So you would think that that would maybe cause him to think twice about some of the things he was posting. But instead of thinking twice, he wrote a post that said, pull my knife, flick my wrist, and slit her throat, leave her bleeding from her jugular in the arms of her partner. That's referring to the female FBI agent.
Oh, wow.
Yeah. So, you know, no individual statement I don't think should be the focus of the conversation, but this is a guy who has a lot of disturbing ideas and violent thoughts, mostly towards women, also towards children, and who is expressing them under the guise of rap lyrics. But I think it's open to debate whether that's pretextual, right? I mean, he's not Eminem. Maybe he admires Eminem, but he's not Eminem. He doesn't have a recording contract. To my knowledge, he's never performed anywhere. He doesn't have a career.
So when the FBI showed up, they basically, fast forward a little bit, they charged him, and ultimately I think they convicted him of felony, essentially death threat charges, right? I mean, they used the argument that he was communicating using the internet and therefore across state lines or something like that, in order to argue that he had committed like felony death threats. Is that correct?
That's correct. So he was convicted of 5 counts of violating the interstate threat statute, which is 18 U.S.C. Section 875, if any lawyers out there are watching. But as you said, it's the interstate threat statute. And so really the issue in this case is, what does the government have to prove in order to convict someone of violating this threat statute?
Right. So, and it's now in front of the Supreme Court, in essence, because he's appealing this. But from what I understand, the question is, how does the law define a death threat or a threat in general? And, I was going back and I was reading SCOTUS blog because I, don't know the law. And they were talking about a previous case, which was the Virginia v. Black case, which first established this idea of subjective intent, which was whether or not someone could demonstrate, or the courts could demonstrate, that not only was a person communicating a threat, but they were communicating some sort of intent to cause some sort of harm in relation to that threat. And I thought this was actually interesting because I, not being a law student, was not familiar with this case. But for those of you also who are like me who don't know this case, it was basically about cross-burning and whether or not cross-burning in and of itself is considered the kind of threat that would also be associated with an intent to harm. And from what I understand, the Supreme Court ultimately ruled that cross-burning by itself is not innately a threat, but cross-burning carries with it, cross-burning with the intent to harm is considered a death threat. Did I get that close to right?
Yeah, no, that's all correct. And just one thing I would tag onto that is that in the court's First Amendment free speech jurisprudence, there is this distinction between speech and conduct. And there is a real question here about, is cross-burning speech? Is it conduct? Is it kind of both? And the justices really didn't come to a clear consensus about this, and I think that that's kind of what tees up the Alanis case.
So I think the thing for someone like myself who's really a layperson when it comes to this is, how do you prove intent? And I think that that's something that the Supreme Court was struggling with a couple of weeks ago. It seems as if, even though Virginia v. Black gave us this sort of a framework where we had to establish intent to harm, we really don't know how to do that. There's no protocol or checklist of things that can demonstrate intent, right? So how do we really prove that?
Yeah, and so first of all, the question is, what kind of intent do we need to prove?
Mm.
And I think it's important to be really specific about that. So the issue in this case is whether the government needs to prove that Alanis had the subjective intent, had some kind of subjective intent to threaten his wife, to make her afraid, or whether it's sufficient for the government to prove that what Alanis did would cause a reasonable person to be afraid. So you can see the difference there, right? And it's a question of whether it's the speaker's intent that we look at or the listener's perception. So does it matter whether he was just joking or just rapping when he said these threats? Mm-hmm. Or does it only matter whether a reasonable person would have been afraid for her safety when she heard these threats? So that's the question.
So if you were trying to demonstrate the speaker's intent, though, would you have to associate that with, like, I don't know, buying the knife that he planned to use to, you know, I mean, how do you demonstrate anyone's intent? I mean, if you put aside whether or not the intended target could feel threatened by it, if you were to just actually go with the idea that you had to demonstrate intent on the speaker's part, how would you demonstrate additional intent?
So just to be very clear, the government doesn't, to convict someone under the threat statute, the government doesn't actually have to show that the person meant to carry out the threats. They only have to show that the person meant to make a threat, meant to put the person that they communicated with in threat of harm. So you don't have to show that the person went out to buy a knife or anything like that. You just have to show, arguably, that the person who made the threat intended to frighten the other person. Is that your kitty cat?
Yes, she thinks podcasts are really exciting, and she comes to visit every time we record. This is the first time she's been on camera, though.
Oh, well, exciting! I'm glad that I'm here for her
her debut.
But I think that that's a really important point, right? So the government, so the harm that the interstate threat statute is designed to protect against isn't the harm of people actually getting injured or killed, right? We have other criminal statutes that protect against that harm. Mm-hmm. The harm is the disruption and the fear and just the interference with daily life that happens to people when they're in reasonable fear for their lives. Right. And so the question is, you know, does the government just have to prove that somebody was reasonably in fear for her life? Or does the government have to prove, in addition to that the person who made the threat intended to make the listener afraid for her life? And that's really the central issue, right? Mm-hmm. Like, does it matter what was in Alanis's heart and mind? And so then that ties back into the question that you actually asked. Sorry for going on a little bit of a tangent there.
No, I mean, because I'm going to jump in on that. So if you want to finish your thought, I'm going to actually jump in on the reasonable person side in a sec.
Yeah, the reasonable person. Man, there's a lot to say about that. But just to kind of tie it back to your original question, how do you go about proving someone's intent? Well, I think that this is something that Alanis's lawyer, frankly, really struggled at in front of the Supreme Court. So the transcript of the argument is 74 pages long. I read the whole thing. And Justice...
More power to you.
Justice Ginsburg, Justice Scalia, Justice Alito all ask different versions of this question. How do you prove that someone intended to make a threat? And I think the best argument that Alanis's lawyer made that I could kind of draw out of that is something like, well, you could look at his computer, right? Like maybe there are other emails that he sent around the time that he made the threats about, you know, I'm really gonna scare the crap out of Tara, right? Mm-hmm. Like maybe he emailed his friend, I'm gonna scare the crap out of Tara, or maybe he kept a diary, right? Mm-hmm. I mean, there could be other evidence of that kind that might provide some kind of insight into whether he actually meant to scare her or whether he was just entertaining himself, right?
But as this case really points out, it's not as clear and dry, right? Like a person can both make art that's intended to be an artistic expression, which we would generally commonly think of as protected free speech, and also make that art with the intention to threaten or at the very least intimidate a person. So I think now we're sort of moving towards this second idea of maybe the we really should be thinking about the reasonable person, whether or not that person would feel threatened by what is communicated, regardless of the intention of the speaker. And I think this has implications, to Alanis' ex-wife, but also to these larger incidents within the last couple of months, that we've seen a lot of death threats and rape threats being thrown around on the internet. So, for example, Gamergate is the current major example that we can point to, with female gamers and video game developers and critics being subjected to all kinds of really heinous death threats and rape threats, some that have pointed out where these women live, and basically becoming so severe that they've had to cancel offline speaking engagements, or even have had to call police, and forced to flee their homes, that kind of thing. And what I find really alarming when we have all of these stories, and these stories are ongoing through the Gamergate, whatever you want to call it, movement, campaign, fiasco, whatever it is, it's still ongoing. What I really find surprising is that there doesn't seem to be any laws to protect what seems to be, at least for these women, the feeling that it's a legitimate threat, that these women are really afraid for their lives. One of the women who was a target of one of these threats a couple months ago, recently her dog just passed away, and she was documenting on Twitter how after her dog passed away, she actually went through the fear that her dog had been poisoned, because it was, there were people online who were actually stalking her, who had threatened to poison her dog.
That's terrible.
Yeah, and so when the dog died,
went through that. Yeah.
Yeah, it was. I think I just saw it on my timeline and read through it really quickly one night, and so it wasn't anything that got news coverage in the mainstream media, but this whole thing, she's going through this tragic thing where her dog dies, and she actually has to go through and have like the biopsy done to make sure that the dog wasn't poisoned when it died, because she really thought that someone might have come and poisoned the dog. And even though the dog passed away of natural causes, it turns out she did have people coming in threatening the dog, and posthumously, taking credit for having killed the dog as well. So she had lots of reasons to think. Right.
Yeah.
So again, I feel like this line has become really blurred, especially with the advent of the increasing use of the internet. That's reduced barriers between people who can communicate with one another, and so we're seeing more examples of people receiving the kinds of communications that, according to what the court is currently debating, that a reasonable person would consider threatening. But on the other hand, I do kind of worry where if we do decide that it's about the recipient and whether or not they would be reasonably in fear for their life, how do we define that? That also seems to be a rather blurry thing. Is it just anybody who says something nasty on the internet, or is there some sort of higher standard?
Well, of course, it can't be just everybody who has ever said something nasty on the internet, right? Because then we'd all be in prison together, right? They just like put a huge dome over the United States and we'd all be in it. So obviously, it can't be that. But the reasonable person standard, and I don't know whether you know this or listeners know this, so I'll just go ahead and say that. The reasonable person standard is pervasive in law. You see it in tort law, you see it in criminal law. It is a very familiar concept in a lot of different areas of law. And so to ask this question, would a reasonable person have been afraid for his life or his safety, and then to send that question to a jury, that is a quintessentially American thing to do. Like, that's a question that has been part of the American legal system for centuries. Mm-hmm. And that is the government's position in this case, that it should be a jury question whether a reasonable person would have been in fear for his or her life or safety.
So the jury sets the standard of what a reasonable person would think, because I would also imagine that would depend on who the jury is, right?
Yeah, absolutely. And there's kind of an interesting connection here to some of what we've seen with Ferguson and, the Eric Garner non-indictment. Mm-hmm. And, I think that there are a lot of criticisms that we could make about juries. At the same time, juries really are the best that we have. Mm-hmm. And at a minimum, when I think about who's best positioned to make a determination about whether a reasonable person would have been afraid for his or her life, if the choice is an 80-year-old white guy judge who's never received a threat on the internet and like doesn't use the internet, or a jury of 12 people of hopefully different ages and different backgrounds, different demographic characteristics, I think the jury's better. Now, is it perfect? And, you know, is it never going to make a mistake? Well, no, of course the jury's going to make mistakes sometimes. But I think that, you know, when we think about a world where things aren't perfect, I think that the jury's about the best that we have. And so bringing together those 12 perspectives, I mean, I think sort of amalgamating those is about as good as we can get in terms of thinking about what the reasonable person actually is.
But I mean, that just reminds me, are we then a little bit concerned about the Alonis Supreme Court case, because we do have, 9 Supreme Court justices, how many of them actually use Facebook or Twitter? Like,
I know. You know, I read the transcript, and, like, some of the things that they said, like
what's a Facebook?
Yeah, right. Like, what's the Facebook? Yeah, like so like Justice Alito, for example, at one point, he talks about someone liking something on Facebook, and then, like, he feels the need to clarify. He's like, you know, they like it. They give it the thumbs up. And so, like, you can tell that, like, one of his clerks gave him, like, a little Facebook tutorial back in chambers earlier that day, or that would be my guess. I mean, to the best of our knowledge, I mean, I guess it's possible that, you know, the justices have, like, secret burner Facebook and Twitter accounts.
You know, I think that would be badass, and I bet you Ruth Ginsburg has one. I bet you she's got one. It's full of kitten pictures too.
You know, I wouldn't be surprised. She is an incredible lady. But, you know, to our knowledge, none of the justices are publicly on Facebook or on Twitter, and I think this is a big problem, right? Like, we have these justices sort of grappling with this problem of new technology that a lot of them don't understand. You know, I read a case out of a Virginia state court not that long ago where a judge, I don't remember, it was a state statute, and I don't remember the details of the case, but what really stood out to me was that the judge analogized Twitter to a bulletin board. And
not so much.
It's just not a bulletin board, right? I mean, yeah, sure, it shares some characteristics with the bulletin board, but it's not a bulletin board. And I just think that there's a certain point, and I think that we're already there, where the justices and judges in both the federal and state courts need to start treating social media and online modes of communication as different. Like, we still have judges, like, analogizing them to things like bulletin boards and snail mail. And that just doesn't work. Like, that doesn't reflect the reality of what these social media, you know, what these different social mediums are designed to do.
So I wonder if maybe we can chat a little bit about how the online technology, social media, Twitter, for example, how that actually might change the nature of what a threat might really be. I mean, you know, the Virginia v. Black case is about cross burning on a yard. You know, all of the context we really have in terms of established case law doesn't involve, you know, existence in a digital space. And one of the things that really strikes me, being, you know, a feminist writer of color, and yourself, a feminist writer of color who wrote my favorite series on online harassment.
Thank you so much.
Well, no, thank you for writing it. No, I really loved it, and so I really appreciate what you wrote about it. And so for those of you who are watching us and who haven't read it yet, in the announcement for this episode, I linked a single post that links all of Nancy's writings. She did a 4-part series on what it's like to be a feminist writer of color and dealing with online harassment, and dealt with a lot of different issues and different angles talking about it. And I read it, like, when it was first published, which is like a year or something, maybe more ago. So it's not, it's not fresh in my mind anymore. So I apologize for that. I'd plan to look at it again. But what I really find interesting is how, you know, Twitter has changed the nature of threats. For one thing, I think it's made it a lot easier to find people's personal information. I think it's become a lot easier to harass people, which is an element of the threat that is a lot harder to do. I mean, you can't burn a cross in someone's yard every night, or you could, but it would take a lot of effort, right?
Right.
But you can set up tweets at someone and tweet them so regularly that you're actually harassing them in addition to stalking them. And that can produce its own level of what we would consider threatening behavior, I would think, in a digital space. So I think that the removal of barriers has sort of changed somewhat the nature of what a threat can be considered. But I wonder how the law can deal with that, because in, for example, a tweet situation, someone might be tweeting or harassing messages to somebody, and each individual tweet might not, it might seem relatively, in the grand spectrum of threats, might seem relatively benign, but I think part of it is sort of this mass deluge effect that you can accomplish through Twitter, or you can tweet at someone and at the same time find their Facebook page and at the same time email them, and so that there's sort of this combined stalking effect that you can create in the digital realm, which you can't do in the offline spaces. So I'm wondering how the law, and if the law, can sort of deal with those aspects, which I think are relatively new relative to being online. I wonder if you have thoughts on that.
No, I absolutely think that it's new and that it's different, and I have thought about this a lot. And the complicated thing is that a lot of this cuts both ways. So the things that make Twitter so wonderful, it's equalizing, it's democratic. Anybody who has interesting things to say, whether or not they're famous in real life, can develop a real Twitter following and become quite influential in terms of public opinion. And all that's wonderful. But at the same time, Twitter allows for anonymity, the equalizing that's so wonderful in some ways, also allows people to have access to one another in a way that really wasn't possible before. So you have people who can send you just horrible messages under the guise of anonymity, for the whole world to see, right? Because I think that's part of it. Like, part of the reason that people threaten other people on Twitter is because they enjoy having the power of being able to publicly threaten someone else, right? Like, it's that humiliation that I can do this to you in public and there's nothing you can do about it because I'm anonymous. Like, that's part of the appeal. Which is sick and wrong, but also true. So I think that this is what's really perplexing, right? Because some of the things that make social media so wonderful are also the things that make it so vulnerable to abuse.
Although, just to play devil's advocate, which nobody loves to do, like, there is an argument as to, well, we're all voluntarily on Twitter. So, for example, when City Park started the Cancel Colbert campaign late last year, early this year, and she was like just inundated with a flood of rape threats and death threats. And I'm on the record saying that that's just not okay, guys. And so, one of the things, that in and of itself sort of became a conversation, sort of a precursor to the more recent Gamergate conversation, was the nature of threats that women of color receive online. And one of the counter arguments that was made is, well, we're all voluntarily online. Do we have any right to this space? It's considered a public space. Where is the boundary between public and private? Like, is your Facebook your house, or is it a sidewalk? And so one of the most interesting, I thought, counter arguments that was made, that I sort of grappled with, was, well, to what extent do we have a right to be protected, or are Facebooks or our Twitters protected from this kind of interaction, considering that we've all voluntarily signed up for a Twitter, and if we want to escape these threats, theoretically we could just turn our Twitters off. But on the flip side, we've got a society now where it's very difficult to disconnect. Someone like Sui might, that is part of who she is, that is part of her career, so it's hard to say just disconnect, because that's the brand that she's building. So it raised all of these interesting questions that I had no answer for.
Sure. So that's actually the thing that you said right at the end was the direction that I was going to go first. So there's a wonderful legal scholar at the University of Maryland named Danielle Citron, and she has a book out that everyone should read. It's called Hate Crimes in Cyberspace.
Ooh.
And it's a legal book, but it's for everybody. It's for a popular audience. It's a really wonderful book, and she talks about how there's a certain amount of nastiness and people saying mean things that everybody has to deal with, right? Like you deal with that just by virtue of being in the online space, and like everybody has to deal with that, and it's not a big deal. But then there are other types of abuse that are more severe, that interfere, and the phrase that Professor Citron uses is that these more severe forms of abuse actually interfere with life opportunities. So they create inequality in the workplace, they create inequality in relationships in terms of mobility, and so at the point that threats have reached a level of severity where they're interfering with someone's life opportunities, that's the point at which we as a society should be concerned. And I think Sui is a very good example. Like somebody could say, well, Sui can just not be on Twitter. But by not being on Twitter, Sui is giving up a lot of social capital and human capital that she's invested in, right? Like there are people who listen to her. She has, I don't know how many thousands of followers, way more than me, right? And it's a career detriment to say, right, well, she should just give all of that up if she doesn't want threats.
Well, there's an actual financial cost to that too for her, because that was, at least for a time, how she was earning her money. She was building this brand, building this following, and using that to book speaking engagements. That's a very legitimate thing to do. A lot of people do that, and being told that she should be not allowed to participate online because of the actions of harassing people who are trying to silence her, that's not just disconnect and be done with it. That is, pushing someone out of her career, really.
And I really want to emphasize the inequality that's a part of all of this, like inequality along racial lines, inequality along lines of gender and sexual orientation and other identity categories, right? And so in my world, which is not the real world, but in my world, right, we don't just have the First Amendment that protects the freedom of speech. We also have the 14th Amendment, which protects equality and prevents, which prevents discrimination on the basis of race. And the 14th Amendment was enacted decades after the First Amendment. And I think in a society that really took the 14th Amendment seriously, we would read the First Amendment and the freedom of speech through the 14th Amendment and say, yes, you have freedom of speech, but the point at which that freedom, the point at which that freedom has a check on it is the point at which you're using speech to create inequality. Just one second, let me take a drink.
Yeah. And absolutely, I think that one of the most compelling things of your series was actually the first part, Nancy. In your first part, you actually talk about how online harassment is used specifically to target women. We see that with Sui's example. We see that in the Gamergate example. It's inescapable that when we're talking about online harassment, we are disproportionately talking about the kinds of behavior that are conducted by people who are not in marginalized identities, targeting people who are of marginalized identities, whether women or people of color or people of non-mainstream or like people who are like LGBTQ or non-mainstream religions or whatever.
People with disabilities, yeah. Yeah,
people with disabilities, but basically ways in which we are trying to marginalize the already marginalized. This seems to be a tool to silence people we dislike people the mainstream dislikes as a society. And I think that we can't talk about online harassment without talking about it as a tool, basically, of oppression. And so I'm going to hand that back to you because you were going somewhere and then you needed to take a drink.
Yeah, I'm sorry. I've had this sort of lingering cough for more days than I'd like to think about. And I think, I feel like I've almost got it kicked, and then all of a sudden I need to cough and I need a drink. What I was going to say is that the argument that you brought up in sort of a devil's advocate form earlier, this argument that, well, nobody has to be on Twitter, nobody has to be on Facebook, nobody has to be online at all. That argument would be more persuasive to me if online harassment didn't have this effect of creating inequality, right? Like if everybody received the same amount of online harassment on average across all of these different identity categories, then okay, we might say, well, it's not really an identity thing, it's a personality thing, right? Like, are you tough enough to, sort of engage in the rough and tumble of the internet or not? But when, like some identity groups are getting 20 and 30 and 40 times as much harassment as other identity groups, I don't think that that is a fair answer. And if you look at the people who are promoting kind of this, I would call it a free speech absolutist or a free speech libertarian perspective, they're not the people who are getting the most harassment. They're mostly straight white men.
Yeah,
I don't want to generalize, and it also, but I mean, I don't want to.
It also goes without saying, though, the threats also, not only are they targeting, people of various minority backgrounds, but they also have a distinctly racialized, misogynistic, very ableist tenor to them as well. I mean, it's not just who you're talking to, but what you're saying. I remember in the first part of your series, you were talking about not just
Okay, so it looks like Jen's internet is on the fritz again. So let me just talk a little bit about some of the themes that I touched on in the first part of my 4-part series on online harassment. And it's a post called Identity and Ideas. You can link to it. You can also find it linked to on my website. And so one of the things that I talked about in that post, and the title really captures it, is that the thing about online harassment is that it fails to substantively engage ideas on their own terms, right? Like it fails to engage ideas as ideas. So rather than engaging with ideas substantively, what harassers and people, more in a more extreme way, people who engage in online threats will do is they will use the vocabulary of race and gender and sexual orientation and disability and inequality along all of these identity categories in order to create inequality. And that does two things. First of all, it avoids the person having to engage with the ideas on the merits. And the other thing that it does is it, in a sense, puts the person in their place, right? Or at least attempts to, right? So if you call somebody a racial epithet or, a dumbass woman or, something like that, you're not just saying you're stupid, and you're not just saying I don't like what you have to say. You're saying both of those things, but you're also saying, and I reject it, not just because of the caliber of the ideas, but because you're a woman, or because you're a person of color. And I think that's what is so harmful about identity-based online harassment, is that it involves this situation where people are engaging in harassment and threats to really stifle discourse and stifle some of the voices of racial minorities, of women, of people with disabilities, people of minority sexual orientations. I think that that's really one of the harms here. And just to kind of tie this back to the Alanis case, I think this is important in relation to Alanis for the following reason. So the big question in Alanis, and I'm going to put it more in layman's terms now, so the big question in Alanis is whether it matters what Anthony Alanis was thinking in his mind and what he was feeling in his heart at the time that he sent these threats or posted these threats about his wife. So does his perspective matter? And the argument that I am inclined towards is that it doesn't matter what he was thinking, because the harm that the threat statute, 18 U.S.C. Section 875, is designed to prevent against is this harm related to, as I said earlier, disruption of one's life. So, if that's the harm that we're worried about, if the harm we're worried about is that people's lives will be interrupted because somebody has engaged in threats that frighten them, It caused them to leave their homes or to take extra precautions or to not be able to concentrate, all of which happened to people who received threats. We don't really care why Alanis did this. We don't care whether he did it because he actually meant to put his wife in fear, or whether he did it because he thought it was funny, or whether he did it to impress his friends. What was going on in his mind and in his heart has nothing to do with the effect on his ex-wife. And the effect on his ex-wife and the disruption in her life is the harm that the interstate threat statute was actually designed to protect against. Hold on for just 1 second. I know Jen has had an internet issue again, so let me just see whether there's something else that I need to do to get her back online. Okay, so Jen's working on the problem. So while she's doing that, I thought that I would take a few minutes and talk about a topic that frankly is a little bit self-indulgent on my part. And that is this claim that people have made that Alanis is a case about rap music. And I could not disagree more strongly with that statement. Alanis is not a case about rap music. I think that, excuse me, I think that a lot of people have tried to make this a case about rap music by making the claim that people don't understand rap music and that rap music is more fantastical, and a lot of rap music involves violent fantasies about doing harm to people.
So I'm back. Hi. And
Hi, Jen.
Thank you for talking while I was gone.
Yeah, absolutely.
So I don't know if you've covered this already or if that was what you were jumping into, but in the last few minutes that we have, I did kind of want to talk a little bit about the use of rap music. It sounds like that's what you were sort of getting to. What I thought was really interesting was, a lot of the free speech cases that have come up sort of tangentially related to this issue have all seemed to involve the use of rap lyrics as some sort of criminal evidence. And, in the agenda that we sent around before tonight's episode, we had talked a little bit about whether or not rap is indeed something, or the anti-blackness associated with using rap as an example, but maybe not rock or country or some other form of music, or maybe Marilyn Manson or whatever, some other form of music that isn't innately tied to black culture. And why is there this presumption of criminality when it comes to rap music but not other kinds of music?
Yeah, and I think that is the argument that a lot of people who are on Alanis's side are making. In other words, rap engages in, certain types. I'm sorry, let me just turn my phone off. Rap artists engage in certain types of discourse that other musical artists don't engage in. And my take on that, honestly, is that it's something of a red herring. So you see the people who are suddenly very, very concerned about how Mr. Alanis and his rap aspirations are being treated. And one of the things that they're saying is, well, Alanis should prevail in this dispute because otherwise it's really racist, because we're not respecting rap as this particular medium. And I think that shows a certain lack of self-awareness, because the stereotyping of rap music is actually coming from the people who are saying that rap music needs to be treated differently. And the implication there is that rap music needs to be treated differently because it's inherently more violent. And that is a claim that I just have to dispute, right? Like, listen, if we could talk about 9 Inch Nails, right? We could talk about wanting to fuck someone like an animal. We could talk about all kinds of metal and rock music. We could even we could even talk about. Oh, sorry about that.
Well,
I
no, no.
got
I mean,
excited by my gesture and pulled my earphones out.
well, so I mean, it's interesting because I sort of I don't really know how I would fall down on this because
Yeah.
on the one hand I listen to rap music, so
Me too.
I don't know that well, but so I don't know that I would necessarily characterize it as innately more violent. I do think that there is an interesting element where certain rappers are considered to be more thuggish, more dangerous when you have, for example, a white rapper saying exactly the same thing and not being called on it. So, early in the episode, we talked about Eminem as an example, and then you gave some quotes from what Alanis was putting up on his Facebook. And first of all, it sounds like terrible lyricism. So I'm going to say that he has no future as a musician, or as a lyricist at least. But it's not horribly different, I would say, from some of the stuff that Eminem has put out there in terms of murder fantasies in his songs. And so there's sort of a degree to which, and then is it really, really different from some like, death metal kind of music, which I don't listen to, so I can't tell you an example of that. But one has to wonder why it is that I don't think that there's a difference in innate violence in these three genres, or from these three different artists of two different genres. But it does seem as if nobody's really going after death metal, and I wonder about that a little bit.
Yeah, I wonder about that as well. And I mean, I think that perhaps that reflects enforcement decisions, in the lower courts, and it may well be that there are guys out there whose postings are taking the form of death metal or rock or country or any genre that we could name, who are not being prosecuted at the same rate as Alanis is. And that would not surprise me at all, given that there are racial disparities in prosecution for basically every crime that exists. That really wouldn't surprise me at all. But I do think I do think that this idea that rap is more violent, but that we should look past that violence. First of all, I don't think it's true that rap is more violent. But second of all, I think the idea that we should look past that violence, that's reinforcing the stereotype. It's not breaking it down. I mean, think about that Carrie Underwood song, Before He Cheats, right? Where she talks about slashing his tires and taking a baseball bat to his headlights. And then imagine that instead of Carrie Underwood, it's a rapper rapping about doing that to his girlfriend's car. I mean, I think the way that we perceive those things is very different, but the Carrie Underwood song is just as violent.
Right, and so I think we're ultimately on the same page, which is, while I think that there is an aspect of threat that's here, I do also think that there should be considered an aspect of threat when Eminem raps about his ex-wives and other just, pure fantasy, which is in some of his for example, Relapse, which is a specific brand of rap that's called horrorcore, and while thematically I think it's a really great album, it certainly falls well in line of rape and murder fantasy. So with that being, it's very problematic content. But on top of that, I think rather than to say we should excuse this kind of imagery when it's coming out of one genre, we instead should be taking that same lens and at least applying it equally across the board. Not to say that we need to limit these sorts of speeches, but at least not have such a clearly disproportionate way in which we view some art and not other art, even though they're all committing the same, what we would consider problematic infractions, maybe, or at least certain things that might raise some eyebrows. Let's not give a pass to Carrie Underwood, even though I don't know the song. Let's not give a pass to Carrie Underwood.
Don't worry, you're not missing out on much. So I think that you're right, you know, and what you said about applying the same lens to all of these different genres of music. I mean, I think that that's absolutely valid, and I think perhaps the place where I would come down is that we should be giving a pass to fewer people, not more people. But then, you know, just the other thing that I wanted to kind of tie into the point that you just made is the concept of the reasonable person that we talked about earlier in this podcast. So, you know, the question is, would a reasonable person be frightened of Eminem? Like, let's say, let's take Bonnie and Clyde 97, right? Would a reasonable person be frightened about, would Kim be frightened by the Bonnie and Clyde song? Well, that's the question.
I feel like Kim should possibly be a little bit frightened.
Yeah, but the thing is, we don't know Kim, right? Like, we don't know what the context of their relationship was at that point. We don't know what he said to her about the song or what she said to him about the song. And I think all of that evidence is something that a jury would consider and debate among the 12 of them and say, would a reasonable person in Kim's position have been frightened by Bonnie and Clyde or not? And I think there's a whole lot of factors that go into that. I mean, maybe one is that Eminem actually is an established rapper with some talent, I would say, unlike Alanis. And there's a purpose to his music, which is to entertain people. I'm not so sure that there's that we can impute the same purpose to Alanis's efforts at rap. And so all of this goes into the inquiry that we have to make when we think about how a reasonable person would perceive this.
Right. Well, can we consider, I mean, I cut out or you cut out, I'm not sure, right in the middle of your sentence, but one thing I was kind of curious to bring up right in the last couple of minutes was, can there be a threat in the situation of like Eminem versus Kim when maybe Kim doesn't feel threatened but a reasonable person would? Is that sort of what you were getting at? Like, what if Eminem makes this song that threatens Kim, or you know, has a murder fantasy about Kim, let's say, which he's made that song many, many times, and let's say that someone else hears it and finds it threatening generically to women, you know, because rape fantasy and murder fantasy is something that he does, and finds that as generically threatening to women, and could
Jen, you cut out for a minute. Okay, so Jen, you cut out for a minute, but I think I see where you're going with this. So your question is, what if a reasonable person or a reasonable jury would see that there is a threat here?
Even though Kim was not threatened.
Even though Kim was not threatened.
Yeah.
Okay. Yeah. I just wanted to make sure. Yeah, because we lost our connection for a minute. So unlike everything else in this podcast, there actually is an answer to that. So one of the elements of 18 USC section 875 is that the prosecutor both needs to show that a reasonable person would have been frightened, and needs to show that the victim was actually frightened. And usually it's not that hard to show that the victim was actually frightened. I mean, she went and got a restraining order, right? Like something like that is usually going to be enough. So if a reasonable person would be frightened, but Kim, who is not the reasonable person, was not frightened, we wouldn't have a prosecution, right?
I see.
Kim would have to be frightened. So that actually does have an easy answer. It might be it might be the only. It might be the only one in the podcast, but there actually is an answer there.
Yeah, and on that note, I think we've hit about an hour, and I think that we both have a stable connection, so I'm like, yay!
Right.
So is there anything else you really wanted to cover with the Alanis case? I know it seems like there's so much more to unpack, and I hope that we did a somewhat decent job of at least touching on some of the major issues. In terms of especially what it means for writers of color like ourselves. Is there anything else you really that you feel like we really didn't go over that we should maybe touch on?
So there's just one other, I would call it a piece of empirical data that I'd like to put out into the world. And this is a factoid that was dug up by Danielle Citron, whose book I mentioned earlier. And one question that she was wondering about recently was, well, how many threat prosecutions are there? And what she found by looking at data from the Bureau of Justice Statistics, which is kind of the authoritative source, is that there are only about 25, on average, about 25 threat prosecutions per year. And that is not very many, right? Like if you compare it to other crimes, like most other crimes, like I'm trying to think of a specific example. That's 25 nationwide, right? So if you compare that to the federal wiretap statute, there's something like 1,500 prosecutions a year. So compared to that, there are basically no threats prosecutions. And so the point that I want to make with that data is that if Alanis wins this case, right, and a prosecutor needs to show that Alanis, had the subjective intent to threaten, excuse me, that's going to make it harder for prosecutors to charge people under the threat statute. And so there's already such a tiny number of cases. It's only 25 cases a year. Well, if it's even harder to prosecute people, we might see that number dwindle to 15 or to 10 cases a year. And it makes me concerned about whether a Supreme Court decision in favor of Alanis here could gut the interstate threat statutes as a mechanism for dealing with online harassment. And so really, I just wanted to put that little piece of quantitative evidence out there. Do with it what you will, but I think that it's very telling that threats prosecutions are already so rare, and they could even become more rare.
And I wonder, actually, since you mentioned this book, and hopefully we can put a link to it with this podcast, I wonder, having read that book or maybe at least looked through it, do you have any sense how many threats women or people online in general receive? Like, I've been sort of wondering this, and I've also wondered if there's any way to even study that or put a number to it. I feel like everything we have right now is just sort of anecdotal data. And I wonder if there's some way to put a number on how much harassment people get, especially women of color.
Yeah, I mean, I think that's a great question, and I don't think there's very good data on it. I mean, it's all anecdata, right? And I think it varies so much from person to person, and there are all these factors like how large of an online presence does someone have, or what kinds of topics do they deal with? As I learned a year ago, one way to get a lot more harassment and threats is to write about harassment and threats and to say that they shouldn't be happening to you.
Right.
So pointing out threats and saying that threats shouldn't happen, well, that's open season. That's basically guaranteeing that you're going to get a lot more harassment and threats. So it's kind of a double bind. But in terms of harassment, there was actually an interesting poll recently that found that men actually get more harassment than women, but it's a very different kind of harassment. Like women, I'm not going to be able to replicate all of it, and maybe we can add a link when you post the podcast as well. But men do get a lot of threats and harassment as well. It's just it's very different in kind. The language is different. The nature of the threats is different, and so I would really love to see just a lot more empirical data on what type of harassment there is out there, because I don't think that we're quite there yet. Some people have done studies. I don't think that there's a definitive account that describes what sort of harassment is going on and then breaks it down along lines of race and gender and so forth.
Right. So if there are any students right now listening to this podcast, I think this would be a really great place for some study, because I also would love to know the numbers, and I agree that
Okay, so I think Jen's having internet problems again, or at least that's what it looks like to me. Um, and so I will attempt to read her mind and finish her thought. So I think what Jen was about to say is that if there are any students listening who are looking for a project, whether you're a law student or a sociology student or a psychology student, I think what Jen was about to say is that this would be a really great thesis, senior thesis, or maybe dissertation, or just a class project. There's a real need for more quantitative and empirical evidence. Is that what you were going to say? I don't want to put words in your mouth.
No, that was absolutely what I was going to say. Okay, so my internet is basically just conking in and out, so we're going to have to call it here. I'm really sorry. And so I just want to thank Nancy very much for coming on tonight for doing this podcast. I hope that you had a good time. I definitely had a good time parsing all of this information. I learned a lot. I feel like I did like maybe the first month of, the first class of law school. I don't know.
That's right. I think the credit will transfer.
And I definitely want to thank all 3 viewers who streamed us live tonight. For those of you who, bore with my technical difficulties, again, for those of you who are just joining in, I apologize for being repeatedly disconnected. You can blame the really cold weather. It was knocking my internet out. So Nancy, thank you for holding down the fort while I was cutting in and out. Nancy, do you want to give us a final summary of where we can find you online, and hopefully people will not be harassing you at these places?
Yeah, absolutely. So on Twitter, I think my what is it even called? My handle. Yeah, that's the word. I almost pulled a Supreme Court justice there. So my Twitter handle is just my name, Nancy Leong. You can also, well, if you Google me, I'm highly Googleable. You can email me at my law school email address, nleong, so just my first initial and last name, at law.du.edu. And you can also go to my website, which is also nancyleong.com. So it's all very straightforward. And my website has more information about me than anybody could ever possibly want to know, including about 7 different ways to contact me. So if you'd like to stalk me, all the information's there.
Go ahead.
I was just going to say I've really enjoyed this conversation. I love the long format, and despite the minor technology issues, I really appreciated the chance to talk to you about this. So thank you so much for having me.
Thank you so much, Nancy. And for those of you who are looking for me, my name, you can't see it anymore because I've been cutting in and out, but my name is Jen. I'm the blogger at reappropriate.co. You can find me on Twitter at reappropriate. And if you are interested in hearing this full podcast, I am going to put it on YouTube starting hopefully tomorrow. Now, because there were so many technical difficulties, I'm actually going to have to edit out all of the snafus when it comes to the technical stuff. So it may take a little bit longer than tomorrow to come out. And again, if you want to subscribe to me, you can subscribe via YouTube at youtube.com/reappropriate or on the iTunes store at /reappropriate. Now, there might be some issues with the audio version now. For those of you who don't know, my blog went through some craziness this past week, and so I've had to do a host migration, and with that, I've also had some issues with the audio version of this podcast. Yeah.
Didn't that happen to you once before in like 2009 or something?
Oh, this one was a much better way. This was
okay.
I had some posts that went really, really hugely viral, and it basically crashed the server, and so I basically migrated hosts. So on the downside, though, it forced me to rethink how we're putting the audio version of the podcasts out. So if you are subscribing via the audio version, maybe this week you might want to check out the YouTube version, because we're not entirely sure how we're going to go back to the iTunes store at the moment. As for the next episode, I don't have anything lined up just yet. I'm still thinking I might take a break for the holidays, but there's been a lot going on, and we haven't had a conversation, an update on Ferguson or on any of the more recent stuff, and the affirmative action debate has cropped back up again. So if you'd like to hear about any of those things or anything else, shoot me a Twitter tweet, something, or an email, and we will try to book a guest for that. Again, thank you, Nancy, for showing up, and for the 3/4 viewers who streamed us right at the end. Somebody popped in and popped back out. Thank you for paying attention, and we'll see you next time. Thanks.
Thank you.